Hello and welcome to another episode of Advoclasses. I'm Advocate by name, title and profession. I was waiting on certain documents to come out and cover those, but since they haven't, I figured I might as well do a filler episode. Today we'll have a look at appeals, what they are, what they aren't, and how you're supposed to act while they are pending. Or more to the point, how you're not supposed to act. Enter one Dlamini Zuma, who, as discussed in my previous video, had her regulations declared constitutionally invalid. She was then given a certain amount of time to reflect on the nature of her regulations and reformulate them in such a way that's not quite as offensive to the Constitution. Now, before we can get to the juicy stuff, I thought that it would be prudent to discuss two principles. The first principle is that when a court case is pending, the parties to that court case have a duty to preserve the status quo of the subject matter of the case. To illustrate, let us assume that you possess a box of incredibly valuable antique marbles. Now suppose I've taken your marbles. You take me to court and you sue me for the return of the marbles. Now, you've served your summons on me and the matter is now officially pending. In other words, some paperwork must be exchanged, but ultimately, I know and you know that a court needs to decide what happens to this box of antique marbles. Now suppose I tell you that you can go jump in a well, and I will be spending the next few days handing out these valuable antique marbles one at a time to every person I see until there are none left. Basically, this renders the marbles unrecoverable because I don't know who I gave them to, and the marbles are so valuable that no amount of money can really replace them. That would also render the court case moot, as since the marbles cannot be replaced or recovered or paid for in any way, then why are we going to court? And there's no order that the court could make that would either replace the marbles or ensure that you got the value back. Now, if things work that way, the legal system would fall apart in about 2 days. But it doesn't, thank goodness, or I'd be out of the job. This is where that status quo principle I spoke about earlier comes in. Should you find out that I plan to distribute your marbles, you have the right to approach the court on an urgent basis for an interdict ordering me to stop. And if I don't listen to that interdict, I could be sent to jail for contempt of court or fined for contempt of court. Now let's take this a step further. Assume you win the marble case and the court orders me to give the marbles back to you. And I say, well, I'm just going to appeal it now. So I file my notice of intention to appeal and all the documentation gets rolling. And then I let you know what? Stuff you for taking me to court. I'm going to start handing out your marbles again. If I were permitted to do this, it would render the appeal moot. Because if I give away all the marbles, it doesn't matter what the appeal court says. The marbles are gone, they can't be replaced, and there's no order that the court can make to change the fact you've lost your marbles. Sounds kind of unfair, right? Well, it is. That's why the status quo principle also applies to pending appeals. It's a clever system, even if it's very slow. So, summary of the status quo principle. Once the papers are out, you have to preserve the status quo. More precisely, the parties in the matter have a duty to ensure that the subject matter of the case does not materially deteriorate or is materially altered. But I can already hear you thinking, Advocate, this is very interesting and all, but what are you on about? And why is this relevant? And my answer is, it's relevant because, well, people don't understand this principle or willfully ignored it, and they did it dumb. And then other people said stuff, which I get to make fun of, so that's why it's relevant. I get to throw shade. Now, for the sake of fairness, legal practitioners disagree with one another all the time. They have differing opinions. Hell, the entire profession is basically just legal practitioners disagreeing, getting paid to disagree. And none of our opinions matter until a court says otherwise. Now, while that might be true, that doesn't mean that I can't poke fun at them. And of course, teach my listeners, something about the law while I do it. Ugh, that was awkward. But I digress. Anyway, back on track. So, Dlamini Zuma decides not to wait for the time period to lapse for her to present amended regulations, instead deciding to appeal the whole thing. The first question that one must ask is, why appeal now? Why not appeal after the regulations were supposedly amended, and those amendments presented to court? And the answer lies in the status quo principle. For you see, appeals take time. And, reading the orders from the judgment that declared the regulations unconstitutional, to quote, during the period of suspension, the regulation published in Government Gazette number 43364 of 28 May 2020 as Chapter 4 of the regulations, designated as Alert Level 3, shall apply. End quote. In other words, applying the principles of status quo, as long as this matter is pending before any court, whether in an appeal or any other fashion, the level 3 lockdown must be preserved. Not only preserved, but preserved as is. Now this principle is compounded by another one, which states that a court order remains in force even where incorrect on the face of it, unless that court order is varied or rescinded or changed by another court order. So let's say that you sue me for $1 million and you win, but there was a mistake with the typing of the court order, and the court order now only says that you won $10. Well, no matter what anything else says, you can only get $10 unless you bring the matter before court again and ask the court to fix the court order. Only court orders can fix other court orders. This principle goes slightly further. Court orders also trump legislation. In other words, you cannot make a law to get you out of a court order. Okay, let's wrap all of this together into a nice neat bow. The powers conferred by the Disaster Management Act is only supposed to be in effect for a set amount of time, 3 months to be precise. As such, the automatic lapsing of the powers conferred by the Disaster Management Act would lapse a couple of days before what would have been the deadline for the return date in the case that found Dlamini Zuma's regulations unconstitutional. But she appealed it in the interim, so it becomes a bit of an academic question. But the status quo principle and the principle that states that court orders trump legislation still apply. And since these principles still apply, let's apply them. Would the automatic lapse of the powers conferred by the Disaster Management Act occur by a fluxion of time? No, because the court order said level 3 stays in place. And the status quo principle entails that the state must, on a month-to-month basis, implement exactly the same regulations as contained in level 3, until such time as the matter is finally resolved. If the matter is appealed, can such regulations lapse? Same answer as before, for the same reasons as before. No. Can more stringent regulations be placed? No. Can more relaxed regulations be placed? Again, no. Can't, no. What about no? No, no, no. We are at level 3 until another court order says otherwise. Full stop. Okay? Okay. But the next question then must be, why? Why appeal this? Why take away your ability to issue new regulations? And since I'm not a mind reader, I must now speculate. And as far as I can figure, it all centers around power, as it always does. Additionally, Dlamini Zuma doesn't strike me as the kind of woman that likes to be second-guessed, and my suspicion is that she will fight this tooth and nail to the end, not out of a genuine belief that the regulations are doing good for the nation, but rather, how dare anyone question her? And while I'm not the biggest fan of Cyril either, he is not a dumb politician. Perhaps I might be giving him too much credit, but my suspicion is he knew that the regulations would be wildly unpopular, and instead of taking the brunt of that himself, he was smart enough to pass that along to someone who's an erstwhile political opponent, and someone who would jump at the chance to have so much power. Okay, I think I've gotten lost in the weeds. I'll get things back on track. Okay, so we're stuck at level 3, and these appeals will be running for quite a bit. Fortunately, they are urgent, so they will be heard a bit faster, as the entire appeal process all the way up to the Constitutional Court can oftentimes take decades, and I don't want to be stuck under a perpetual lockdown. Although I would wager that Dlamini Zuma would want us to be under perpetual lockdown, since that gives her absolute and tyrannical powers over the everyday lives of every citizen, a power trip that she seems to be enjoying. Again, lost in the weeds, back on track. So what were the grounds of the appeal based upon? Regrettably, I've been unable to get a hold of the Notice of Appeal document, and should I wait any longer, the story will go colder than it is already, and doubly so with so many other constitutional challenges on the near horizon. So for the sake of expediency, I will commit the cardinal sin of relying upon media reports. Before I get into it, remember I said in my previous video that the judgment wasn't perfect. It was not as precise as I would have liked, and this does leave it open for appeal, although I still think the appeal is a scummy move considering how milquetoast the judgment was. I'll just go back and think on it a little better, why it's okay for people to sit in a taxi 10 at a time, but you can't go for a haircut when everyone's wearing masks and gloves. And again, this is why I say this is about power. It's about wanting to stay in control, as the judgment was hardly controversial enough to justify a last stand, a hill to die on, to justify what will probably be a fight to the last. So the next question we must ask is, when may one appeal? And for that, we head to the Superior Court Act. Section 17 of that act gives us the requirements for when an appeal may be lodged. Now, appeals can be quite complicated, so for our purposes, let's consider 3 requirements. A document called a leave to appeal is filed with a court, and on that document, you set out a basic argument as to how the following 3 requirements are met. Requirement 1. The appeal would have a reasonable prospect of success. Requirement 2. That the order granted by the appeal court will have some practical effect and is not just for academic purposes. Like in our example of the lost marbles. And requirement 3, where the decision sought to be appealed does not dispose of all issues in the case, the appeal would lead to a just and prompt resolution of the real issues between the parties. This last one requires a bit of explanation. It basically allows a party to appeal an interim order, where that interim order, if the appealing party is successful with their appeal, wins the case for them outright. Let's use Dlamini Zuma's case as an example. She was ordered to come back to court at a certain date, but if she wins on the appeal and the appeal court finds that the regulations were not unconstitutional, then she straight up wins. And it doesn't matter that there were additional steps that she needed to have taken to bring the regulations before the court again. The notice of appeal is then brought to the court where they want to appeal to. The judges of that court then consider the merits of the argument and then decide, yes, you can appeal, no, you can't appeal. And if leave to appeal is granted, then a new court case takes place in that higher court, subject to the proviso that unless exceptional circumstances are present, you're not allowed to go outside of what was said in the previous court. And that means no new evidence. Well, generally speaking. But there is also a danger in this, because just as you are appealing, your opponent can do a cross appeal and has a right to answer to your appeal papers. In that way, your opponent has an opportunity to fix any flaws in their own arguments, as long as that argument stays within the 4 corners of the record of the previous court. Basically what it comes down to is one party says that the judge was wrong and the other party says that the judge was right, and then they provide reasons. Right. Now that we have a basic understanding of how appeals work, let's get into the points. Dlamini Zuma's first point of contention is apparently that the attack on the regulations were based on undefined regulations on undisclosed grounds for unknown reasons. I personally think this is a weak argument, but they put it in as a catch-all. It's phrased like this so that on the day, they've got some flexibility as to where they want to argue. Then they take another shot in the dark by saying, to quote, "It made it impossible for the minister to know what case to meet, and that this fundamentally violated her right to a fair hearing." End quote. Now, without having access to the actual court papers, and without having watched the entirety of the trial, I can't really comment much on this, but my suspicion is that this is grasping at straws to make their appeal document seem more sensational. I mean, if they make the argument that their right to a fair hearing has been violated, then surely the appeal court must hear the matter, regardless of whether the rest of the points are good or not. And if this just so happens to keep the lockdown in effect and keep Dlamini Zuma in power for a bit longer, what a coincidence. As a third point, Dlamini Zuma makes a big song and dance about, well, when the papers were filed it was level 4, but now it's level 3, and we answered on level 4, but we didn't answer on level 3, so this is super unfair, except for the fact that level 3 contains very many of the same provisions as level 4, except it's slightly less onerous, and if they failed on level 3, they definitely would not have succeeded on level 4. Finally, she seems to attack the lack of clarity in the judgment. I understand that time was an issue, but the judgment would have been so much better if the judge just made a table saying, here are the valid regulations, here are the invalid regulations. I mean, reading the judgment itself, the judge does describe in a narrative way the regulations he doesn't have a problem with and those that he does. The judgment more illustrates his thinking as to how to come to the conclusion whether a particular regulation is correct or incorrect, valid or invalid. And he placed that burden on Dlamini Zuma and her co-ministers to sit down and go through the regulations line for line for line, running through this procedure, running through the tests of constitutionality, and then finally coming to a conclusion along with justifications, and then present those justifications to the court so that the court can ensure that the proper steps have been taken. But as it's not hand-holdy enough for Dlamini Zuma, she refuses. She would rather appeal and stay in power and oppress everyone further, unsurprisingly. The implication of the judgment is basically that Dlamini Zuma and her co-ministers working on this did not actually think this through. They didn't apply the rationality test at all, but rather formulated the regulations arbitrarily. And arbitrary formulations in terms of public law is a big no-no. And I say this because, well, when Fita in the smoking case asked for the minutes and the documents and the rationale, Dlamini Zuma included documents dated after the decisions were already made. In other words, she was looking for an ex post facto justification for her decisions. Now, I am planning to cover the cigarette ban case in due course, once the judgment is handed down. And as that timing question was brought up, I'll wait for the court to decide what is true and what isn't. For now, suffice to say, there appears to be a pattern showing Dlamini Zuma likes to shoot from the hip when deciding what citizens can and cannot do. And that, I think, is going to come back and bite her. And it won't be very long before it does. Oh, and how we will laugh. I'm Advocate. Thank you for listening.